Now, Kofi, what do you have to say from the way the minority seems to approach the issue, and as a member of the Ghana Bar Association, the association statement that it has also issued, but even before all of these issued their statements, I think the Information Ministry had issued a statement that suggested that something wrong had gone on, and I was going to investigate the matter further.
Well, so let me say, I think I agree with the minority's resistance to what has happened. That is what a minority must do. When you see something going wrong, you speak up. Even if we don't agree with all the details of it, this is what a minority must do: raise the issues and force them. The next point that has to be made, I think too much law is being spoken around this thing. Look, it is a legal issue, but this is a small legal issue driven by big politics. And the politicians are making a mistake treating it as a legal issue and trying to use the law to explain it. Look, if anybody is doubting what I'm saying now, tomorrow try and go and release people in custody from a court. Take 100 people and go to the smallest court and try to release even one person from custody. Then you will see what the Ghana police can do when they want to do something. Kweku Ninja went on a frolic of his own into a bush to defend his land. And he was shot in the bush and buried under a foundation. And concrete was poured over him. The Ghana police investigated, found him, dug it up, got the people and dealt with them. They don't joke when they want to do their work. So let's get it right. This is a small legal issue. We are bantering about whether it's nolle prosequi or whatever it is. It is a situation where the big politics of the day is driving something very simple. So the politicians are playing with fire, treating it or trying to explain it away with the law. Let's get it right. The AG does not investigate. I'm trying to avoid the law and explain this thing to ordinary people. The AG does not investigate. It prosecutes. The police find fact. They investigate. If you go and do something, the police has to arrest you, assemble the fact, not law, and then present the fact to the AG. Then the AG will assemble the law on it and use that to determine whether there is a case or there is not a case and whether they should proceed to court or not. That is what happened. The AG, and what I mean is the specific person there who wrote that report, did nothing wrong. All she did was say, you've brought me a series of facts. When I have assembled my law, I realized this one should not go to court because if it goes to court, we'll be whipped. There's a story of a man who stood and told his mother-in-law that I will kill you with juju. I will curse you, you will die. And he was seen doing all kinds of things. 1 week later, the woman died. People arrested him, took him up, and they tried to prosecute him. And the same thing happened. The prosecutor says, you can't take this to court. So let's get it right. The AG didn't do anything wrong. But look at what has happened. You have a situation of the Delta 8. They are sent to court, and before they were sent to court, there was a huge national outcry about this matter. The police failed to send sufficient forces or sufficient men to the court to protect both the court, the judge, and the general public, and the whole thing. We are told the barracks is 5 minutes away. Okay. Now, the first failure to send the right number of men is a failure. If the court was in session and you saw the tension rising,
a reinforcement of about 20 police officers.
Thank you. You failed to do that. Then these men walked into the court. You failed to respond in good enough time. They freed the people. You failed to arrest them. They themselves came back and reported. And I just told you the story of Kweku Ninja, who was taken out of a foundation. In the presence of so many people, in broad daylight, in a court of law, you fail to supply evidence that is sufficient to convict not one, not two, not three, so many people. Look,
it ought to be stated also that out of the 8, 2 of them deny being members of Delta Force. 6 of them say, yes, we are, but we're not part of the process.
Yes, which I think is fine because they will defend themselves. But that's why you investigate. And I'm saying this is not one of those investigations which is difficult. When the Ghana police wants to work, I say if you like, try it next week.
You're suggesting complicity.
I am suggesting complicity. And I'm not mincing words about it.
So what? The police is being deliberate, that it cannot identify the people? Or, first of all, inability to arrest them on the spot was deliberate?
The police lacks no ability to arrest these people. I am saying here that it will not be possible to convince a room of intelligent people that the Ghana police, given their capabilities and being the best police force in West Africa, could not find people who invaded a court in broad daylight and could not assemble the necessary evidence to have them prosecuted. So please, we should go back on this matter and let's stop treating it like a real legal matter which we are splitting hairs to try and find. It's a political issue, and I think the political leaders must not play with this matter. They must find a way to deal with it.
You say the AG's advice or the state attorney's advice, you find nothing wrong with it. The minority say they find something wrong with it. The Ghana Bar Association says this should not be the end of the of the situation or the road. AG's advice does come in a year, 2 or more. Did you find that in this case the AG was a bit in a hurry?
I don't think so. Mainly because I don't know what was going on behind the scenes. In my own mind, if the police assembled the facts and brought it to the AG, I think they will ask them questions. Please, have you checked this? You should know that this is not strong enough. Go back and forth a bit, you know. I sense a bit of frustration in the letter that was written by Ms. Simmons. It's as if, look, you are not giving me good enough material to go on with. So honestly, again, I can't blame the AG. But again, you don't know the forces behind this thing driving it. So I will give full excuse to the AG, and I agree with the Ghana Bar Association, of which I'm a member. This must not be the end of the matter. I agree with the minority. We need to go back on this thing. But I'm saying that, look, I know NPP people who are incensed by this thing. I don't know any well-meaning Ghanaian who is saying that this matter must go without
in one breath,
treatment.
You say she did everything right professionally, so you agree with Martin Amidu, for example. But in another breath, you seem to also suggest that they would have asked that question or that question. The minority says, these are the questions that were not exhausted. And I'm adding up to say, as a practitioner, you are aware that when advice has to come from the AG, sometimes it takes forever, and you have to pursue it yourself. And we don't like that. We complain about it. We want it to be quick and fast. But in this case, looking at the other angle from which you look at it, could the conclusion have been a bit to say, go back and get the job done?
Could, yes. Could, yes, because if the AG was sufficiently passionate about this, if they had a certain personal interest, take the particular person involved, the lady herself, she could have said, this is not enough, go and bring me back some better information. Look in this area, look in that area. It happens all the time. So the AG technically does not investigate, but it can guide the police where to look and how to find the necessary evidence upon which a conviction can be based. You didn't see that here, which is why I'm saying this looks like a legal matter. It is a political matter. And honestly, we all should address that matter. That's why I agree with what the minority is saying, that look, the political leaders should try and find a way to deal with this matter in a way that diffuses it properly. I know where their pressures are coming from. These are our people, but we should not condone criminal, behavior. So I agree with you. The AG could have pressed more, could have worked with the police closer, could have given them pointers. But if the person does not, that is why I'm saying that if the police want to work, they work. But I don't know the pressures they are coming under. And I'm saying the Ghana police is the best police force in West Africa. If they want to work,
so in this matter, you say you agree with the minority, you agree with the Ghana Bar Association. So the way forward should be, this matter should not end?
It should absolutely not end, because it will be terrible impunity for anybody to frontally attack a court. It's the last bulwark in our democracy. If they are worried about punishing their own people, they
like you said, they should go and interview the judge who was in the court that day. The two police officers says we can't identify the people. They should go and look for the lawyers who were there. They should go and look for the court officials who were there. What do you think? They may also be afraid that they cannot point out these people even if they knew them?
I never tried to tell people how to do their specific job. But all those options are open. Because, Samson, something that actually happened, okay? It is not like we are conjecturing it. It actually happened. You cannot tell me you can't find any proper evidence on it. We saw even ordinary people taking videos. And you know, even the video we saw, which was not too good, if you pause and slow it, you can identify people. So I'm not here to tell...
You cannot identify people in the video freeing
Yes.
the 13.
I know.
You can identify some insulting and saying things.
I know. I said you can identify people. I didn't say the people who did it.
Okay.
Now, those people, if you went back to them and tried to do some real work, they will also identify somebody else. We cannot tell the police how to do their work. Okay, but it is not impossible to explain to a room of intelligent people that under these circumstances, something that happened in broad daylight, you cannot find any.
Is it
evidence.
also possible, final question to you before we move to Kweku, is it also possible that those who were freed on the day themselves may know those who freed them and ought to be part of this process of identifying who was involved?
Absolutely. And this is where plea bargains come in.
Yes. No conspiracy was
plea bargain. Do you know, my personal view is that the original crime, okay,
that's the Delta 13.
Yes. It's not as bad as attacking the court.
Okay.
It's my personal view. When you attack a court, you touch everything. So this is where they should use this to free those other people. I would be happy if one of them came and identified the people who freed them. Okay, and they are giving some sort of a plea bargain. So again, we can't tell the police how to do their job. Okay. But they found Kweku Ninja under foundation.
All right.
They can do this one if they want to do it.
Yes, Kweku, your first response, immediate response when this matter came up was that this was politically imprudent. That's how you shouted. Yeah. Have you, upon seeing the advice proffered by the senior state attorney and listening to the Attorney General, sort of government backtrack a bit in the manner in which they also responded, taking a different view of the situation?
My first response was in the form of a text message to cover his program.
Right.
And while it's true that I said it was politically imprudent, I also said the advice itself could be legally sound. The text is still available, that based on the docket, the duplicate docket that had been given to the lady, the advice on its own legally was sustainable. The political imprudence that I talk about was because, and I'm talking here from a layman's point of view and the street corner, was that I thought the trial running its full course would have been better.
Yeah.
If a court were to discharge and even acquit at the end of the day, it's easier to market that kind of verdict, even though there are people who complain. I'm talking not as a lawyer. I've heard
these are professionals doing their work. How do they gauge how to do that work, you know, to make it politically prudent, to suit the political parties? Marketing of it.
That's not what I'm saying. They have to ignore all those things and do their professional work. After all, they've been doing it, and courts always come out with verdicts not always in favor of prosecution. The prosecution loses all the time. They win some, they lose some. Many examples exist. I am saying that considering the nature of this case, I would have preferred a court verdict running on its own steam, rather than an advice coming from the AG's department that truncates it somewhere along the line, however legally sustainable that was. It would not have provided ammunition of a nuisance value for political opposition to capitalize on and run out with it.
We, the same people, would have blamed the Attorney General for doing a shoddy job, even if the judge did not, in the end, did not do what judges like...
the verdict will be based on what the proceedings that would have
judges like Ajet Nassam had done in the Woyomi case, that this was a shoddy job. You know, we would still have blamed them.
No. The proceedings will be live to be seen by everybody. We would all see it. And the court verdict will come out. That's as I said, it's not a legal opinion I'm expressing. I'm expressing a political opinion. And in any case, this case has both legal and political legs. The Attorney General, after all, is also a political appointee, even though he's a creature of the Constitution. She or he exercises political decisions when they are taking some decisions that are of judicial significance. Let's not make it look as if they are totally isolated from the politics of the day. They are not. Now, you see, as I speak here, I've seen only the advice. I wish I also had access to the docket, the duplicate docket that was returned, which also will give me the insight as to the diary of action. The lady may have seen it because she points it out there.
She gives you ideas of what she has on the docket.
But I would wish to have the full benefit of the duplicate docket. I've been studying some dockets, and it gives me an idea that sometimes there are many things there that if we were aware of, maybe we will not talk the way we're talking, a layman like me. See, the minority's view was that, and I take a certain stand. I found out some few things. The lady initially, whilst processing this advice, I'm told initially had some consultations with the DPP.
Director of Public Prosecutions.
In Accra?
But when she was taking her final decision, there was no connection between her and the DPP. Now, I think if that had happened, perhaps a certain advice would have come to her that, look here, tell the police, instead of going to withdraw, to go and do further investigations. I think that would have been more useful.
All the time. All the time.
After all, the discharge means investigations could continue. It's relative to the 8 that there's no evidence. But there could be others out there who were the perpetrators. And indeed, it wasn't ghosts who went there. They were live human beings. So there's clear point that there are people who perpetrated that act and who can be looked for.
Right. And in fact, because of that, Kweku, I asked the question, what was the police about when they went picking the 8 guys? And in fact, after picking the 8 guys, look at the process. They have a 9th person they have named. And they say the person is on the run.
All this time.
So how did they identify that person to start with?
Yes.
How did they identify the 8 to start with?
I'm sure.
To come to give a statement put on docket for the Attorney General's advice in which you say you are unable to identify the individuals.
And indeed, we all saw this coming in a certain way because the lawyers for the 8, if you recall initially, claimed that the 8 were not the actual culprits. And that they were even busted far away, and that we saw that there could be a difficulty. But we're assuming that the police may have done their homework. It appears, the ordinary people,
we assume.
Clearly, failure of intelligence, because police uses intelligence to do investigations. But intelligence on its own is not enough, because through the investigations, you have to get some prima facie evidence to send to court. It is obvious that relative to this 8, that is based on this advice, and I presume safely on the docket, this 8, it will be very difficult to nail them. That is why I say the police ought to do further investigations. Now, but the minority are pointing to things like Twitter, Facebook,
the judge,
social media,
the clerks.
Yeah, but that's why I'm wondering, the docket, whether the diary of action does not tell us that some attempts were made maybe to talk to 1 or 2 or 3 people and they declined, or had said they had no evidence or had no information.
She would have said so.
Not necessarily. I've studied some other dockets. I've been studying the Afoko docket. They sometimes just rely or highlight the essentials. There are many other points that she in this case, she may think that, look, it's of no...
Sometimes even indicating time.
Yes, so I've seen that, and that's why I'm making this point, that there are instances where some people were called, if you read the diary of action, spoken to and all that, but they are not in the AG's advice that finally asked the court and the police to prosecute Afoko. Okay, so the issues being raised could be answered. For the judge, see, what could the judge have seen if indeed the crowd moved in?
Mad rush,
Are we expecting the judge in that state of mind and at that period really to have been able to identify any of the people? I don't think it's practicable.
How is that possible?
But the
So,
accused-
for all you know, they may have asked the judge. The judge will say, look, in this state, I couldn't have identified anybody. The senior state attorney may not have found that necessary to put here, even though it will be in the docket.
I asked a question also about resort to the 13 who were freed. They would know who freed them.
Who are
And
easy
you
to
expect them
identify.
to be sincere and honest.
The
And give
process,
you-
the court process allows a situation to compel.
You are the lawyer.
Or even offer
compel
them something.
To give you. When I say I didn't see them, what can you compel me to say I saw them? You see, it's at the end of the day, it's becoming clear that perhaps we need to modernize our court architecture. No, have CCTVs and things placed there.
Yeah.
Technology could help. Elsewhere, when we praise them so much, a lot of it is based on technology.
Right. The
Even
video
if
you
in the
saw too,
streets.
what do you make of it?
It's an amateur video, which is, it happens now, citizen journalism,
Right.
it's all over the world, but it depends on its quality and the contents. And sometimes it can be applicable, for at least of use to investigators.
What you have seen, what is its value, if any?
No, this one is useless.
Useless.
Yeah, it's rubbish.
Completely.
Completely rubbish. It has no evidential value.
Insulting
And
the judge is also a crime. I mean, it's actually a part of the
you mean
disturbance.
those, how did you hear anybody insulting the judge? Outside there?
Yes.
On the streets?
Yes.
I didn't
no,
hear.
not on the street, just by the court room where you had one person come out
The
of the
main
courtroom.
entrance.
You
saw
know
them
what?
clearly insulting the judge.
Well, I didn't hear that, but
In
if,
chief,
assuming with that admitting it's true, I think the key element was those who invaded the courtroom and allowed those guys to escape from lawful custody. Why? So we couldn't
Kofi
get
says,
them.
talk to these people. It is possible
I'm saying-
they will give you leads.
I'm
There
saying
are many ways
we
of
don't
doing it.
know.
This is one
I that's
way.
why I keep on saying I really would love to see the docket.
Okay.
And see the thing.
All right.
See, but there's a final thing that
Okay.
there's something else I want to
Right.
add. I realized that some media houses, and I will mention names, published some stories to the effect that the public prosecutor, the ACP, the Ochredaku or so, had said in court that the Attorney General actually herself personally advised that the prosecution should withdraw.
I see.
I have the newspapers here.
Okay.
Apparently, they picked that story from Star FM Online. But it appears Star FM Online did a correction
Okay.
because they republished the thing, and there's an editor's note here. It says, in an earlier version of this story, we wrongly attributed to the prosecutor at the center of the release of the 8 members of the Delta Force, ACP Ochredaku. We unreservedly apologize for the mishap. Apparently, it was the lawyer of the accused who was making the point, and even the lawyer was making that point based on the fact that the senior state attorney works on behalf of the AG. So that is what was said, and the public prosecutor has not made any such statement.
Okay.
The AG
Okay.
should be left out of
Now,
this.
wrap up with you so we move on. Obviously, as far as Kweku is concerned, should this be the end of the matter?
No,
Should this be the
no,
because
no.
you are saying that there should be further investigations.
Yes, I believe that to locate, locate, and apprehend the actual perpetrators, there's no turn back on that.
I see.
Yes.
Okay. Yes. What do you have to say?
Yes,
And please, and let's not forget, the 13 are still on trial.
Yes, they are.
The 13 were earlier found, convicted, and sentenced, if you remember,
On their own
from
plea of
lawful.
guilt.
allowing themselves to be rescued.
Yes.
Yes.
So again, I find it difficult.
Custody.
Yes, I find it difficult when the impression is created as if nothing at all is happening.
Right.
There. There are
They were in court,
contradictions.
is it yesterday or Thursday?
Yes.
And it has been adjourned.
Yes.
So,
So it's
they
a
are-
mixed
yeah.
bag.
Right. Okay.
Yes, Sam. Very importantly, the charge of conspiracy is missing in this matter. Now, if I am sitting in court in lawful custody, I have been denied bail, and the procedure I've seen, and you've seen it all the time, is that immediately the order comes that bail is denied, you are put back in handcuffs. You're moving, even if you had any intention, you contemplated moving, you were limited with the speed with which you moved. Were the 13 people placed in handcuffs immediately after the judge
13
denied?
or 8.
13. I speak of the 13. They absconded.
Reversing to the
You
initial.
understand? Now, for the aid to create the conducive environment for you to abscond, you needed to be free, to be able to speed, to be able to move with speed in absconding. They were not restricted. So we suspect that the whole process was done in such a way as to ensure that this took place effectively. You understand my point? Because you have to charge the 13 for conspiracy or abetment.
But you can't prove it.
But here you are saying the police conspired with them.
No.
You are suggesting
no,
that.
No, we are saying.
They didn't restrict
You're
them.
saying that
we
the
are saying
13
the 13
would have conspired with the 8.
Because
Yes.
once you agree,
But he's saying the police created an environment that
yes,
allowed
we are
that.
also alleging
So
that.
you are saying the police conspired?
Yes, like you said, complicity.
Okay.
You see, we are also alleging that for the 13 to agree. Look, if I were one of them, I would have sat quietly in court for the commotion to abate and for me to be taken to.
That's why they
up
pleaded
to
guilty.
custody. No. It's not about. It's at the time when they were brought to court and they were denied. So we are saying even charging the 8 in this matter, they ought to have slapped a charge of conspiracy or abetment against the 13. In this second case,
difficult to prove that.
no,
It's a
it's not
prerogative.
difficult. It's not difficult. If somebody conspires from home that I am coming to court, if conditions were such that I would do things in court to favor you to escape, and you act in a manner to escaping, then when I am charging them in this matter, I ought to charge you for abetment.
You and I
But you
know
see,
that.
the
You
difficulty I
understand?
have is this.
Yes.
The difficulty I have
Yes.
is this. When the gentlemen were coming to court, they were anticipating that they would be bailed.
That is right.
That
Yes.
appears to be.
That is the anticipation
And-
of everybody who is in custody.
Yes, so I'm not sure how would they plotted ahead of time that in case we are refused bail, let's do this. Is that what you're saying?
No.
In fact,
You see,
the advice
I
that
speak-
came in the advice, it said that in the course of the court proceedings, the sitting judge ordered the 13 accused persons must be remanded into prison custody for 2 weeks to reappear it should have been on the 20th of April 2017. After the judge's pronouncement, the accused became very furious and openly showed disregard to the judge's decision.
Yes.
They objected to the judge's decision. At that moment,
accused.
at that moment, a large crowd of persons, some of which were also members of the Delta Force group, were outside the courtroom observing proceedings after the judge's order to remand. A section of the crowd outside entered the courtroom and openly disregarded the judge's ruling with force, tried to free the accused persons in the dock whilst causing a lot of commotion. The two warrant officers and so on and so forth.
Yeah, so they all came anticipating a bail. They plotted ahead
You see-
that look, in case we are not refused bail, then we'll do this. Unless that's what you are suggesting.
You see,
but I
when you
find
are
that
charging,
difficult.
when you are preferring charges,
I'll come to you.
You look at the
to
facts.
take a break. Yeah.
You look at them. It's only the fact that helps you to charge somebody. The facts are that you are under lawful custody. The order has come denying you bail. So you
I
remain.
think your point has been made.
Yes.
They should
So you
not.
remain-
They should not have taken advantage of what happened.
Good. So once
Yeah,
you
but
do,
that's why they were
you
tried.
ought to have been
Yeah.
charged.
They
pleaded guilty.
No. That was
pleaded
not the
guilty.
charge.
They pleaded guilty.
No.
The charge, there was no conspiracy charge or abetment charge.
Just a quick one in the interest of
I
time.
want to
Yes.
defend
You are
it. I'll
suggesting
respond
that
to
the AG could have proffered more charges.
Good.
Right. You and I know that facts can support a plethora of charges, but the AG must decide which ones he's going to apply and which ones he's
Sustainable.
going to sustain and pursue. So much as you have a point, I don't think we should worry ahead about it because really it's the AG's choice to. They can have 7 charges, he chooses 2 because all of them carry a maximum sentence that
Right.
will cover this. So you are right, but really I think it's their prerogative.
So see, you don't believe as the NDC that even when the 20 other reinforcement police officers came in, that what you are being told is that all of them also did not see one person that they can help to identify in this matter, not even a single one, and that in all of these processes, it's sort of orchestrated, it's planned. But there is individual effort that you can make on your own. You are saying this video is of great value. If it is, for purposes of contempt, then individuals can initiate the process of contempt. This is not a superior court.
I agree.
So it cannot do what the Supreme Court did by doing itself. Even in the Supreme Court, you realize that individuals went there to initiate the contempt proceedings against the Muntie 3. Yes. But just that the court decided to put that one aside.
It coincided with their own initiative.
So if you feel that the video has such value, why are you not, relying on it for an individual to initiate the process?
That the appropriate authority to do so is the agent. But the final point I want to make is that there is a complainant in this matter.
The complainants I can't identify.
No. It is not the court warrant officers who are the complainant. There's a substantive complainant. Read the statement. Yes. What happened to his statement?
Yes, who was not present at the scene.
Yeah.
You understand? So it is curious that somebody will make a complaint about a matter that he did not witness.
Okay, so
and we are disregarding his statement in this matter.
I'll keep to Kwamka. Yes. Okay, Kwamka. So what's going to happen going forward?
Mr. Fiamepo, as an Attorney General's department headed by Madam Gloria Akufu,
and as the
Deputy Attorney General, we are bent on ensuring that there is justice and there is equity and there is fairness in the system, and that everybody can go about his or her duty without fear or favor in this particular country. That is our mandate. We will not shake on it. But you see, in doing so, we are mindful of the fact that we are supposed to go by constitutional injunctions and other statutory provisions so that we don't run the nation into a kind of a persecutorial state rather than prosecutorial. So what we intend to do, and which we are doing, is that the minority and any other Ghanaian who has any evidence of value in resolving this particular matter, which has become an albatross on our neck, is free to provide same to the security agencies for investigations. And if it is established, as has been the case, and it has already happened, we will say that, look,
you're saying that you will not go looking for the further information.
We will look for it, but I'm saying that any person who is in custody of any such piece of information or evidence of any value to the resolution of this particular matter is free to provide same to the police.
So as far as you're concerned, this matter is not over?
It's not over because they were discharged. You do recall that they were discharged. All of us have discussed this, and we have arrived at that conclusion that a discharge and by law is not a bar to further prosecution. Okay. If in certain cases where you are acquitted and discharged, if certain new facts which were not within your contemplation even emerge, you can be retried on the same set of facts based on the fact that certain new facts have emerged.
So the Republic is expecting to go back to court in this matter,
provided we have new evidence which will actually aid us in prosecuting successfully the matter.
The evidence now even available today, so you don't need new evidence.
Hold it. We are saying that the docket we built and which was submitted to us, professional advice was proffered. And we are saying that professional advice was in consonance with what was available at the time.
Yet you summoned the person who gave the advice to come to Accra to do what?
We did.
You summoned
and the DPP did that.
Yes.
And DPP did that because DPP had to actually interrogate further to know what was actually in the docket and the details, and everything was forwarded to her. She had to review it.
Is this matter serious to you?
Very.
If it is,
very.
Why don't you have a very senior people, maybe the DPP himself, on this beat?
But that's what we have done. As I indicated yesterday.
No, you are now saying you are doing so. And Kweku was saying that there was a slip in terms of even consultation that led to this situation.
You see,
my suggestion to you, listen, don't treat this thing lightly.
We are not. We are treating it with all the seriousness. We are not treating it lightly.
So, is that your advice?
Let me give you an example. The chief state attorney in Kumasi was summoned to Accra.
You see,
and together with DPP and the Attorney General's department, we sat on this.
Even the police who we are blaming, the IGP traveled to Kumasi.
At the highest level, my brother. And let me indicate this, something, that nobody at the Attorney General's department is taking this matter lightly.
Okay.
We are taking it at the highest level. But I'm saying that if care is not taken in an attempt to satisfy public outcry, we may end up persecuting, which we should avoid.
Prosecuting. Okay.
We should avoid that.
Okay.
We should make sure that we follow due process and get the evidence to nail people.
In all of this, are we learning the biggest lesson about the need to avoid the wrong and what I call the wrong and traditional approach of arresting, remanding suspects before gathering or investigating, instead of the reverse, which should have been the case? You investigate, get the evidence before you arrest.
Yes.
Are you going to?
Going forward, we have to start
Because that's
thinking
what our
about that
police do.
seriously.
Don't start thinking.
Yeah,
It's
you
a
see,
well-settled rule.
that is the rule. And I think that we have to, going forward, implement that to the latter. You see, sometimes you get people in custody. After 48 hours, there's no evidence against the person. So even at the police station, they leave you to go. That should not be the case.
Right.
Otherwise, what we're going to do is that we just infringe on individual liberties at will. If I look at your nose and I don't like you, if I look at your nose and I don't like you, the next moment you are in custody. And that's not good enough.
Happens.
So yes, what we need to do going forward is to ensure that we investigate, get all the evidence available, arrest and proceed from there. Because something
You simply go to a police
the last
station,
thing I just want
report that my neighbor has done ABC, and the police officer is attached to you to go along
We are
with
getting
to go and pick
serious.
up the person
Just a
without
little-
a shred of
a
evidence.
little information on
Maybe
that.
somebody quarrels with a policeman's girlfriend.
There are occasions in the past, and I know that my brother knows, where purely civil matters sometimes
Yes.
end up in the hands of the police.
Right.
And they show you where power lies. They just put you behind bars. If you bring the money, we'll
But
leave
some
you
of
to
them
go.
are understanding.
Pure-
You go, you
pure
speak to them, they
contract.
understand the process,
Pure-
and they
pure
let it
contract.
go.
They understand
All
it.
right, all right.
So, going forward, we are going to ensure that everything. And you see, something. This last bit, which is very important.
Right.
You see, we have stated that such high-profile cases, after we have resolved this particular one, going forward, such high-profile cases, whatever advice you have proffered must proceed to the DPP's table for
Okay.
review before it is released.
All right. That's interesting there, but I seem to have some information that what he's saying is not incorrect, that they don't intend to leave the matter at this point. Whether it is public pressure or whatever it is, they intend to proceed and to find the evidence where it can be found and go back to court. Let's see how that pans out in the coming week. We take a break here. We'll be right back.